that we will be violating our own constitutional principles, because then the court should guard against, because the guardian of the children, the court should guard against the children suffering, going to despair, now relying on the state for their life, whilst the deceased was alive, was looking after it.
One thing you did also ask me to do before that the second applicant who paid 40,000 per month and is that not what the fund should?
My Lord, I agree with the court. It's one of the things that we also admitted, and that's why in our own prayers we have said any other alternative relief. Yeah. The prayer that we are happy about, which will obviously satisfy the applicant today, is that Alexander Forbes retains the money in line with the prayers if it's granted by the court. If it retains the money, then any other dependent will be able to make a submission, which will also be determined. Because indeed, I agree with the court that the court will not be in a position to say, this is 40,000, this is how much. But now, at this point in time, the respondent say the money should be taken in the estate. But our submission, my Lord, is that we, in the estate, as we speak about, for the 44.7 million is what the deceased has lived and died for. At this point in time, there is not any other money that can look to the estate that the estate has. So it is correct, and it's our submission, it's our prayer, that the main prayer today will be to keep the money with Alexander Forbes. Once Alexander Forbes keeps the money, then all other beneficiaries can approach Alexander Forbes in the meantime, whilst all the other processes of the estate and other things are ongoing. Because as we speak now, there's no executor, there's nothing. Right. But then life has got to continue and maintenance has got to continue. In other words, it has been signed off, but it has not yet been paid. That is why Alexander Forbes is here today.
So what, according to you, did Alexander Forbes trustees do to comply with the conditions of Section 37?
It is for that reason that we feel that at this point in time there's not been compliant with that if the payment was to be done.
And your fear is that money will be paid out to one person.
Definitely.
Whereas it is pension money that should be dealt with in another.
As it is a part.
I get it. Influence.
My Lord, I've made my submission with regards to that, and that is the only thing. The other thing that I want to indicate, because what is before court also is the issue of the second applicant. We brought this application because the second applicant is a dependent, and she's studying now in the University of Cape Town. Yes. And because she's studying in the University of Cape Town, there is money fees that have got to be paid.
Yeah, you see, but that is my point.
Yeah.
If the money is pension,
yes,
the people that are in control of that fund is the trustees of the pension.
Yes.
They must determine everybody's dependents. We need one by one. How can I, as a court, now intervene when they have not done their job? That's it. Just a minute. That's the first question. The second question is, if the fund has acted not in accordance with Section C, isn't there a procedure in terms of Section 57D where a person aggrieved can go to the fund and lay a complaint, and that ultimately constitutes a administrative decision which can later be challenged before?
My Lord, I'm with the court in that manner. We are with the court in that manner. We are happy that the money is still with Alexander Forbes. The only competing views today is that their respondent is saying that the money needs to be paid to her. And we are saying that no, the money cannot be paid to her. The money should remain with Alexander Forbes. So we don't want the court to do. The court today, our prayers is not to say the court need to pay money. or order the payment of money. But that the court should order Alexander Forbes, once there is interdict on the money, then Alexander Forbes should go back and do its work in line with its policy, because then it's where the honorable court definitely agrees with us to say they must do their duty in line with the. And if they don't do their duty, then we can come back to court and say they've not done their work. But today we are saying we are fortunate, because through the application of this court, the court has, the Alexander Forbes has not paid the money directly to the account of the nominee. What also surprised me was that in their own policy, they've got to make inquiries. They've got to make sure that they check who the dependents are. They were not supposed to release them. They were not supposed to even come with a decision to release the funds, because there is 12 million. There it's 44 million. There are dependents who are going to be left in destitute if this money is paid, because there is no any other money. So based on that fact alone, I'm of the view that Section 37 is applicable. And my Lord, I also want to submit that in line with what the court has said, it obviously the fund itself, they have not done its work correctly, because instead of just any other person paying out money, they need to have due diligence. They need to, it's a fiduciary duty that they've got to play. Now, what it means is that if I take money and put it in Alexander Forbes, then when I die, they are not even going to make investigation. That's what they are saying. Then any other person that I've nominated, which their own policy is saying is just a guide, because it's their own policy. That is a guide. It's within the discretion of the trustees to make a determination. So obviously, they are overlooking their own work. My Lord, let me also submit through case laws which I want to quote, which speaks about the living annuity. It's issued under Alexander Forbes Retirement Fund with the same number. I'm not going to waste time on the court. And also the number in which it was issued. This is a fund issued living annuity regulation under the Pension Fund Act, and accordingly subject to Section 87C. It follows that the nomination of the fund of the first respondent as the sole beneficiary cannot confer an absolute entitlement. That is what it has got to be emphasized. It cannot confer an absolute entitlement, because what they are saying in their paper is, I'm nominated, I'm going to benefit. And what is of constraints, my Lord, is that the first respondent is aware of the children. The disease that we are talking about, or the beneficiaries, maybe let me use the word beneficiaries, children, beneficiaries, were on public TV, my Lord. When the deceased died, and obviously on his funeral, all the 7 to 8 children were there. But she doesn't say in any way in her own papers that I concede that they are dependent. What she is saying is that the policy, I have been nominated. And obviously, she had a legal duty. She had a legal duty. She has had an omission. She had a legal duty to inform even the fund that yes, I'm nominated, but then they are dependent. And these are the dependents because they are well known to her. When the deceased was alive, the applicant indicated that at some stage she was the one who was said to be that we will be violating our own constitutional principles, because then the court should guard against, because the guardian of the children, the court should guard against the children suffering, going to despair, now relying on the state for their life, whilst the deceased was alive, was looking after it.
How can we take also ask you to make it order that the second applicant be paid 40,000 per month and 7,000 per year? Is that not what the fund should?
My Lord, I agree with the court. It's one of the things that we also admitted, and that's why in our own prayers we have said any other alternative relief. The prayer that we are happy about, which will obviously satisfy the applicant today, is that Alexander Forbes retains the money in line with the prayers if it's granted by the court. If it retains the money, then any other dependent will be able to make a submission, which will also be determined. Because indeed, I agree with the court that the court will not be in a position to say, this is 40,000, this is how much. But now, at this point in time, the respondents say the money should be kept in the estate. But our submission, my lord, is that in the estate, as we speak about, for the 44.7 million is what the deceased has lived and died for. At this point in time, there is not any other money that can look to the estate that the estate has. So it is correct, and it's our submission, it's our prayer, that the main prayer today will be to keep the money with Alexander Forbes. Once Alexander Forbes keeps the money, then all other beneficiaries can approach Alexander Forbes in the meantime, whilst all the other processes of the estate and other things are ongoing. Because as we speak now, there's no executor, there's nothing. Right. But then life has got to continue and maintenance has got to continue.
All relevant implications are therefore that the insurance relationship with the annuitants is purely contractual in nature. There is no indication in any of the legislation that applies to living annuities, i.e. the Pension Funds Act and the Income Tax Act, which defines a living annuity, Financial Institutions Act itself, and later contract included between parties, that the living annuity are regarded as trust or property. Neither is there even a hint of a fiduciary relationship.
In that case, it's what court?
That's the Supreme Court.
See the citation.
Lord, it's CM versus EM, 2020, brackets 5, SA, 49, SC.
Thank you so much. All right. Mr. Trier, so if that is the crux of the matter, I must decide whether or not Section 37C is applicable. Yes. And if it is applicable, the applicant must go.
Well, then there would be an issue with regards to the amount in payable, 40,000 and 124,000.
Remember, that is then for the trustees' fees.
Yes, no,
because they cannot give 127,000 and another one to them. They must determine everybody's needs.
Each of them. That is each section 37.
Yeah, so that is my point.
Yes.
The crucial issue to decide is whether or not Section 37 is applicable.
Yes.
And if it is applicable, then the trustees must make an election to pay that.
Yes.
Are you with me? Any other argument?
Well, just to emphasize on the facts, we have facts in the structure. Section 37C is not applicable. So we're not denying there is no trustees in this
So
thing.
where will I look at the terms of that contractual relationship? Shall I not look at that statement?
Lord, that the contractual terms, how the living annuity is explained. My colleague has requested certain documents from the second respondent. That appears on Annex RA7 of the plan. The court will note what is stated there from clause 3 onwards says that the living annuity is where falls within the ambit, this living annuity from the second respondent, where it falls within the ambit of the Income Tax Act. And what should happen? What is the process upon that? Well, I'm not disputing that if Section 37C is applicable, that the trustees should take charge of the script. But there's no trustees in this event because it's an investment, it's a risk policy. The annuitant is not set in stone that it will gather those funds because it's an investment that falls within your system. No, that's the card. Thank you.
The second is from what kind of thing was this? The big annuity work.
As a users, I confirm that it was in fact a living annuity.
Yes, and that's section
And that's
37 apply.
in our opinion, that section 37 does not.
Why do you say so?
Yes. For the same reason I was about to cite the same case that was cited by the first respondent of CMS's VM, that in terms of section 1 of the Income Tax Act, the annuity falls outside what is defined in the
But that is the That's it, the income tax act, where section 37.
So as much as was said by the first respondent, I do not believe that section 7 principle C would be applicable. This would be a contractual
It
arrangement.
is because you said that the income tax act provides.
Yes,
You have nothing to say that the income tax act is not qualification.
I would say that in the original trouble with respect to what it is applicable to, which is retirement, benefits, retirement annuities, and preservation funds, which the product that the deceased taken was not.
So when we start looking at what this thing is, that the money is in,
The first respondent has referred you to the.
is that an actual honest file? Yes. I will have to verify that. So we confirm the money still with you. That if I say section 37 seems applicable, you must then look into section 37. And how long will it take you to determine who the people are, so that I don't have people waiting for 10 years?
With that, we don't know the beneficiaries before I speak.
You have court papers where all the beneficiaries are listed, or most of them. Do not have.
I know that it comes specifically to us, I do not have instructions.
Is there any rubbish of instructions? Is there any problem that I ordered from community to start investing and report back to this court with this? Will there be anything wrong with that?
I do not have.
Yes, I'm asking you, if you do have that issue, it's fine. You might not have an issue, but you might have to tell, to make a case that I was wrong. Tell me, would it be wrong for me to do
I do not have instructions to take the matter in for
Please
this,
take
and I
this.
provide reports.
Thank you very much. And take instructions is that specific issue. Because it's people that are making to be maintained. And you can't make this act for years. It is the same number as the schedule I refer. However, the contract provides for something else. The contract is a policy schedule. The policy schedule makes references at various places to a policy. So, for instance, in clause 1, it reads as follows: anniversary, the date on which this policy started. Again, the word policy. Secondly, policy code. The living annuity policy, including all attachments of any schedules, applicable forms, and arrangements to the policy. Then, 3D, the amount that you pay to Alexander Forbes investments for the policy benefits in terms of this policy. So we have a situation that appears to be a long-term policy, insurance policy. And because it describes the premium, then it goes on to say, when does the policy start? This policy will start at the date that we receive and accept your application, including all relevant supporting documents and your first premium payment. I'm turning the pages. Beneficiaries is in clause 6 of the contract, clause 8. You may nominate any one or more beneficiaries who are likely to receive the annuity payment or lump sum payment on your death. 8.2. You may at any time during your lifetime either change or cancel the nomination of beneficiary on written notice. 8.3. If you don't nominate a beneficiary, death benefits will be paid as a lump sum to your deceased estate. Then, in clause 25(6) of the policy agreement, it says as follows: procedure on death. In line with the relevant regulatory provisions and legislation, the following will apply on your death. Bullet. If the beneficiary is a natural person, death bracket, a real human being, right bracket, the deceased beneficiary may either elect payment of a cash lump sum or the payment of an annuity. Such annuity may be purchased from us or another long-term insurer in terms of the relevant regulatory provisions and legislation. Second bullet. if the beneficiary is not a natural person, for example, a company or organization, including a trust, then the cash lump sum benefit will be paid to the beneficiary. This is clearly at odds with what the schedule says, which was attached to the paper. In terms of the schedule, section 37C of the pension funds. Now, it's a large amount of money. People are in dire need, it appears, of support. But I cannot take a decision when I'm confronted with two conflicting documents. I'm of the view that the only party that can explain this difference is Alexander Forbes. You agree with Alexander Forbes. You say Alexander Forbes merely advanced the court's decision. That is not enough. I need Alexander Forbes to give me evidence. Why there is such a discrepancy? Because ultimately, the central issue to decide is what this money was invested in. If it is a life insurance policy, well, the beneficiary must get the money back into the business. That's how it works. If it was a pension fund, the distribution must be in terms of section 37C of the pension fund. So the crucial point of to decide the cannot decide because the rules are wrong. This is the order that I follow. Unfortunately, I cannot give a judgment today. I will have to look at further evidence. This is the order. The second dispute, that is the Forbes also, is hereby ordered and directed to file affidavits explaining the discrepancy between the policy schedule and the schedule of benefits and the policy document. They shall file an affidavit by no later than 69 hours on a Friday. Friday. 26 September 25. The other parties, that is the applicant and the first respondent, shall be entitled to file affidavits in response of the affidavit of accepted respondent by no later than Monday at 16 hours. That is Monday, is it 29? Monday 29 September. This matter is postponed to Tuesday, 30th September for further. Thank you.
We're at 9 at the moment.
We're not fighting, we're not lovey-dovey, but yeah. But knowing each other, we give each other, we just as shocked as everybody that we're in a dark. Because if it wasn't for Tamara and her lawyer, we would still be in the dark.
Because I'm sure you can also kind of add it up to that. Because it wouldn't be here if there was a relationship. She would have sat down with children as she knows them to discuss this. But the fact that we meet here, we cannot even cover it up. There is no relationship. We left to the funeral and this is how we meet again. Yeah, so, yeah. But my summons from the lawyer Tamara and says this is it. We saw we had responded. So while we were still trying to actually understand what does it mean, and then it just flooded on social media.
It's not really summons. Yeah,
What are they like?
It's
court documents.
yeah,
whole bunch.
because on behalf of the kids. Yeah, so we have interests since he knows that we also want the same. So hence why we came here to support and care for ourselves. But as for the Forbes and whatnot, we've heard, we've been there, but Nova today, we also heard about it last week. Yeah.
But we're not mad because she's fighting for things we wanted, not things listed on that document when we read it. And then we also spoke to her, said, no, we will support you. Everything you have written there that it needs to be sorted. And we want to be part of his pension, we want access to the farm, and all of that. So we said we will be right behind you. Because
Instead of coming the one, we decided to Like Papa used to say,
Before we
unite.
start
Unite. Yeah, so, yeah.